from page 4 of a recently filed federal civil rights lawsuit, which details 4 cases in which all the defendants did conduct or participate directly or indirectly in the conduct of the affairs of the Superior Court and Court of Appeals through a pattern of racketeering activity within the meaning of 18 U.S.C. section 1961. These cases are not about incompetence. Incompetence is accidental and criminally negligent at worst. These cases are about corruption, the well-orchestrated, very deliberate violation of state statute and constitutionally protected liberties. For example, in the Amador County case, the children's court-appointed attorney stated on the record that a sexual assault examination by UC Davis Medical Center demonstrated digital penetration and genital injuries in one of his clients. Then he turned around and filed a motion to suppress all the evidence of molest at the custody trial. When a man rapes a neighbor's child, he's criminally prosecuted. But when he rapes his own child with the same or even more evidence, he's able to get custody. These are civil cases which are unlawfully being held to a higher criminal burden of proof. Incredibly, when the criminal standard of evidence falls short, the child who discloses a crime and the parent who attempts to protect the child are both punished, re-victimized, and endangered. Are California courts telling children that molestation is acceptable?
Thank you, Karen. And now we'd like to come to our keynote speaker for today, Karen Winner, who is an author of a book, Divorced from Justice, and a New York investigative reporter. She has investigated the Sacramento family law courts for the last several months and will unveil her findings today. Thank you, Karen.
I want to give people an education on how misconduct takes place under the guise of the law. Can I have a report there? I was commissioned 2 or 3 months ago by Connie's group to investigate some popular psychologists who are used widely in the court to evaluate cases involving child sexual abuse. I was also asked to look into allegations that a popular court-referred therapist allegedly sides with molesters who she treats along with the victims at her agency. I found that there was a pattern that was shocking to me in that it was so consistent. I examined over 15 cases. I found that there was no neutrality. I found that through vague, evasive, and omissions that evaluators were able to create basic hoaxes that were perpetuated on the court. Hoaxes in which they used a discredited theory called parental alienation syndrome that no medical school accepts, yet is used in the California courts. Think of it. No medical school accepts this diagnosis as legitimate or bona fide, but it's used in the California courts. Think about it. And these evaluators would take these children. There were 5 or 6 cases where there was medical evidence of physical penetration, genital injuries, all kinds of injuries to the genitals. And they would somehow discount these injuries and instead focus attention on the parent raising the allegations, so that these evaluators would then recommend unsupervised visitation or unsupervised access to the children, or in some cases, custody. Mm-hmm. Now, I know that it's still in the abstract when I talk about it, so I want to get down to the concrete and show you exactly what I mean. There's a case, Klausner v. Miroff. The mother was very concerned that her child was being abused. She called CPS over 20 times. They didn't believe her based on the recommendation of the evaluator who said she was alienating the child from the father. Now, there were 3 psychological evaluations done in this case. In the first one, the evaluator found that the father had a drinking problem. He might not be suitable, because, here we go. This evaluation was done by a very respected evaluator, Bruce Ebert. He's a lawyer, and he's a forensic psychological evaluator. If you can read this, it says, finally there is evidence of an alcohol problem. Vern is clearly well defended, does not want to admit he has a current alcohol problem. There is some evidence noted above. I think it is prudent to require alcohol assessment and treatment. 8 or 9 months later, there was another evaluation done by Sidney Nelson. It has a very big aura of respectability. In fact, Dr. Nelson works for the Board of Psychology reviewing ethical violations of psychologists. But he serves as an evaluator in the Sacramento court. Sorry. Here we go. Dr. Nelson writes, in conclusion, Dr. Ebert believed there was some evidence regarding alcohol abuse. He believed Vern clearly had an alcohol abuse problem, though it was somewhat unclear as to whether there was a current drinking problem. Tell that to the judge. What happens? It throws confusion on the case. In every case I examined, Dr. Nelson's recommendations were followed by the judge, which brings me to another problem. And I've confirmed this with lawyers. Judges rubber stamp these decisions, even when they know there's abuse. There was one case you'll find in the report where the judge was very troubled. She said, well, it's apparent that there's been sexual abuse. The medical reports have demonstrated it. But I can't go against the experts. Well, guess what? Judges can and should be independent enough to make their own decisions. There is nothing in California law that says a judge has to follow the psychologist, the court-appointed expert witness's recommendation. There is nothing in the law. And yet you'll find over and over and over and over again, they rubber stamp these decisions, and there is no accountability. There is none. In 1996, the Sacramento Civil Grand Jury investigated 5 of Dr. Nelson's evaluations. They didn't name him, but I talked with litigants, and his evaluations were the ones that were used in their own investigation. And they decried this use of parental alienation syndrome, but it didn't change anything. People presented there was a complaint with 40 signatures attached the following year to the presiding judge, who has the power to delete the questionable psychologist from the court-approved list that the lawyers used to select these psychologists to do these evaluations. That judge had the power and responsibility to look into those complaints. Instead, these litigants were treated as stigmatized troublemakers. And as a result, you have what everyone is talking about, a crisis in the courts. Let's go on. Oh, okay, here's the third evaluation. Yet another one in the same case where there was a problem with drinking. The mother continued to complain. She continued to go to CPS. She continued to get shot down and discredited for trying to protect her child. Just in February of this year, a third evaluation showed that she was right. The child was being endangered. But guess what? The evaluator did not make any recommendation to reinvestigate or turn that child over to the protective parent. It says in summary and recommendations, Vern Miroff made some recent errors in his parenting of the couple's 7-year-old daughter. This is what she was complaining about and which got her stigmatized by CPS. It says he hit her with a belt. I saw photos myself, belt marks across the thighs, 7-year-old, and sleeping with her nude in the same bed. Is that appropriate? Does anybody think it's appropriate? He's saying that since the evaluator brought it to the father's attention, the problem's corrected, that's it. That's February of this year. Now, how do you think that child is going to respond in this kind of situation? What kind of social problems down the road will she face due to her being victimized and forced to live with an abuser? Will she be a drug taker like the man's other daughter who was on methamphetamines, which is documented? Will she become a prostitute like so many people who are abused do? Will she marry an abuser and repeat the cycle over and over? And guess what? Taxpayers are paying for this. You're the ones who elect the judges. I can go on about my own position, but let me go on with the findings, because I'm appalled by this. I've done a lot of investigations, and this is the worst that I've seen. In Karen Anderson's case, she was subjected. Karen Anderson is Amador County woman who, the evaluator in that case admitted that he was grossly negligent when the Attorney General brought charges against him of gross negligence. He admitted that he didn't do the investigation properly, only he defended it by saying he didn't think he had to. This is in the court papers, and there's no dispute over that. That was his defense. So he was faced with a full hearing, and he decided to plead no contest, civil equivalent of no contest in an administrative hearing with the Board of Psychology and the Attorney General's office. In the meantime, the question pending is, are those children safe? No official wants to address that fact. And they've stigmatized Karen Anderson because they do not want to deal with a problem in their court. Instead, they made her go into supervised visitation. She has no criminal background, no psychopathology. She was tested. There's no problem with her parenting abilities. And yet, the children's therapist and supervisor, who was in apparent seeming conflict of interest, because the woman who was running the supervisory agency, Marcia Knoll, was also serving as the children's therapist. Marcia Knoll has a lot of influence over the local courts. A lot of families get referred to at the after program. And this is what Marcia wrote to the court about Karen Anderson. I'm sorry. She had never diagnosed Karen Anderson. She had never treated her, and yet she accused her of having something akin to a legal Munchausen by proxy. Now, does everybody know what that is? Okay. Munchausen by proxy is the disorder that's accepted in the books, whereby a parent will hurt their child in order to get attention from a doctor. Now, there's a big controversy over whether that's legitimate, but it is accepted. It's misused, but it's accepted. Miss Knoll, who has a master's degree and is a family counselor, went further. She accused Karen Anderson of a legal version of this. And this is what she wrote to the judge. She says, Miss Anderson's escalating behavior reinforces the suspicion that her crusade has nothing to do with the welfare of the children. She goes on and says, I must point out, she says, you may recall that Miss Anderson, in an evaluation of Miss Anderson, it failed to identify any major psychopathology. In other words, she's got a clean bill of mental health. However, I must point out that such evaluations are not reliable when measuring characterological disorders. She never treated her. She wrote this to the judge. Karen Anderson has had no contact with her children on and off for a couple of years now because of this kind of letter. This is how it's done. You want to know how the misconduct occurs? This is how it's done. I'm sure that you know a phenomenon, Munchausen by proxy, the emotional illness. Mother knowingly inflicts bodily harm on her offspring. Then the mother can bask in all the concern and attention that is lavished upon her. How important she becomes. Note that the perpetrator, usually a female, exhibits a more than passing knowledge of medicine. Now, I would not presume to diagnose someone I had not treated, wink, wink. Moreover, to my knowledge, there is no diagnostic criteria for the legal equivalent of Munchausen's. That's called cover your butt statement. But it is suggestive that if you replace hospitals with courtrooms, medicine with law, illness with molest allegations, and doctors with lawyers, one might suspect that the Hoverson children may be dealing with something more sinister than and addition to alienating behavior. Now, Ms. Anderson told you that there had been sheriff's reports, there had been medical reports. It's an easy case to prove legally. There is so much evidence. But it has gotten reversed, and she has suffered the equivalent of wrongful conviction through this kind of punitive action against her in retaliation for going public. And that's another problem. People try to raise legitimate concerns with the court, and not all evaluators are bad. Some are very dedicated, some are very good. Not all lawyers are bad. Some are extremely dedicated and will go to any length to try to help their clients. But we have a system that has created the opportunity for the unscrupulous, the incompetent, and people with self-interest who are not on the side of children. Now, since Marcia Knoll runs a treatment program for molesters, she subjected Karen Anderson to the same rules. Let's see. Here we go. Okay, let's look at rule number 4. The supervisor must see and approve all toys, gifts, cards. Gifts are only for special occasions, are to be given equally to each child. Now, her parenting abilities were never in question until the allegation of abuse was raised, and then she got accused of emotional abuse for raising the allegation. So they imposed this rule on her that is, I've talked to national experts, they say this is inappropriate. These rules are designed for dangerous parents who can't be trusted with their children, not for the ones that are trying to protect their children. Saying all body contact must be approved. That means you couldn't give them hugs, no kisses. Let's go to a current case. The evaluator, Sidney Nelson, was diagnosing the mother with possible alienation. after the abuse allegations were raised. Possible alienation. Oh, I'm sorry. Let me get that. And it sounds very clinical, very objective, but it's hocus pocus because there is no syndrome. There is no disorder like that. See, he says, therefore, I believe this matter has a very high risk of evolving into a parental alienation situation. Evaluators who use this discredited theory have dropped syndrome because it's in such disrepute to call something a syndrome when there's such a controversy over it. So now they're still using the same methods, but they've dropped the word syndrome. They're just adding things like situation and that. So they're saying she's too young at the time to become actively involved in alienation. She says, he goes on to say he doesn't think the father is a danger to his daughter. Now, in this case, the father was on probation for DUI, hit and run, has a big gun collection, unattended in the home according to photos, and she had restraining orders against him for prior violence. The mother did not know what was in this report when she became so afraid that she fled with her child. And I don't know if you're familiar with what happens when protective parents flee, but they get caught and then they get immediately placed with the other parent. What happened was she got caught, and the child was placed with the father, and the judge asked Sidney Nelson to do another evaluation. Why? Because the father had been charged with elder abuse the week previously. And Dr. Nelson had those documents. I have correspondence showing the police reports and the judge's request. And he said, I don't have it here, but it's in the report. He said that the father was safe. He said the father was safe. Less than 3 weeks later, this police report was issued. I responded to a fight between a mother and son. It turns out that he really beat up, allegedly, I do not know how this case turned out. All I can tell you is this is what the police report says, that he allegedly severely assaulted the mother with blood all over the place, which the child saw. Let's see if I could read you something. This is, yeah, here we go. She says, they put the wrong name, the mother's name is Ruth. She said, I could see she was bleeding from numerous cuts on her hands and arms. She had a large swollen bleeding bump on the top of her left hand. She had blood on her face, small amount of swelling on the left side. I could smell the strong odor of alcoholic beverage. This is where the child was living. And why? Because of the influence of Dr. Sidney Nelson. This is not an anomaly. This has been going on for over a decade. I just happened to look at 15 or 20 cases, which I have, and I have available all the evaluations for review, just so that you don't have to take my word for it. He goes on to say that the child witnessed this, and as a postscript, that child was taken out of the home that day. See, I searched the home, I photographed the injuries, I asked her what happened. The police said, did he hit you? She said yes, nothing that they couldn't handle. I requested a CPS worker. This is based upon the grandmother's intoxicated nature and propensity for physical altercations. They had been called to that residence before. Why wasn't that addressed in the evaluation? This is a man who evaluates that reviews ethical complaints for the Board of Psychology. This is not about incompetence. This is not about, oh, I just missed that. I'm sorry, I made a mistake. This isn't about that. I'm afraid that this is something else. I can't understand the motivation, but this is not about incompetence, that these people are placing children with abusers with this kind of evidence. This is exactly just a fraction of what is going on. This child was whisked into foster care. She's now languishing in the dependency court, and her mother still doesn't have her. Her mother has a clean record of health. Now, how is that child going to grow up thinking that her mother abandoned her, exposed to blood and gore and drinking and I don't know what else, according to all the allegations in the report? So, as a result of these findings, I am suggesting that these evaluators be suspended, be taken off the panel of the court-approved list that is used by judges to appoint them, that an investigation is done of Marcia Knoll and her treatment methods. I'm suggesting that legislators seriously consider a special statewide grand jury that would have powers and checks and balances so as to avoid the potential for misconduct in these cases. This happens because nobody's watching. That is why this is happening. And I'm suggesting a federal investigation into the practices and conduct of these I'm finished. Anybody wants? We will take questions.
Yes, now's the time that people can ask questions of any of the panel members, particularly Karen Winter.
Yeah. Hi.
Hi. My name is Deborah Irish, and I'm from Marin County, and a large group of us are here. They're here today. Karen Winter also did a report in our county, and we have been met with all of our efforts and labeled as disgruntled parents. That family law cases are just a terrible situation, and that the judges, and I'd also like to ask Karen Winter, my comment, is not only the evaluators, but the attorneys that are put in place for children to also be accountable. Because we have found that the churning process to be in litigation for 3, 5, 7, 10 years is because the cases go from a child having an attorney. Then the attorney puts on an evaluation. Then the evaluator puts a therapist. And all of these people are making a living from our children. What would be the motivation for these judges, attorneys, and evaluators to stop this when they are making a living off of these cases? I want accountability from not only the judges' decisions, but by these same attorneys and evaluators. And we must have, for our children and their future, a video camera, something that they'll be able to view, to see for themselves, and give our children their due voice for their futures. And if we do not do this now, these children will not have any regard for our justice system, because right now there is no justice system for them. I also just want to finish and make the comment that even if you don't have a child, even if you think I am not going to get divorced and have this problem, judges and attorneys who do this to children will also touch your life, because their hand is also in probate and trusts and wills. And anyone who can do this to a child will also affect your life. So please stand up. We're having a recall in Marin County because we want to take it to the people and have them decide, and have these judges put on a ballot They're running unopposed for 7, 9 years. People don't even know who is the judge and what they stand for and what their decisions are. And we must stop it now. So please stand up and help. We need your body. We need volunteers to collect signatures of registered voters. And I'm hoping that in this county they will also do the same thing. It is only the people who can take this into our own hands and do something now. Thank you.
Karen, this morning you referred to independent federal investigators as being in need, as you highlighted in this report. In the Marin report, you also incorporated that into your list of recommendations. So my question and query to you is your ideas, thoughts, how we go about bringing these investigations about.
Well, I've found that any bureaucracy moves slow, and that it really boils down to individuals and the agency. I used to work as a policy analyst for consumer affairs in New York, and I found there that the bureaucracy works slow too, unless you pushed it along a little bit. And you do that through finding individuals who you can get sympathy from. That's really, I think, the only way. I mean, it's going to sit on somebody's desk otherwise. Yeah.
How about getting rid of immunity in all the positions along the way? The judge's position, the prosecutor's position, make them all accountable to the people they injure.
Yes.
I think that's a great idea. This is very good.
Karen, I was anxious to ask you a question or talk with you about this. I'm from Los Angeles County, and we have been trying so hard for several years to get an investigation going, and always something happens to impede it. And we would really like you to come to do an investigation for us, because we have several problems there, including this judge's trust fund, where they appear to be, they are laundering money, and these evaluators and the judges are in a fiscal bed together at the risk of our children. And the evidence of the sexual abuse or physical abuse is suppressed, as in your study. And again, the protective parent is the one that is the culpable parent and gets monitored visits. It's very common. In addition to which, the monitors also have paid into this judge's trust fund in a somewhat circuitous manner, but still it happens. And I want you, and many others want you, to come and do an investigation. So I wanted to let you know that.
Okay,
and
well, we can talk about it afterwards.
yes, we will, but we really need you there. It's very corrupt.
I'm honored to be able to help. I really didn't choose this issue, it chose me. When I did a report 10 years ago for the agency I worked for and found corrupt business practices among divorce lawyers. So I've done a lot of different consumer writing, but I find that this is an issue that won't go away. And, yes, I know Joe from Santa Clara. I did a report a couple of years ago here.
Yes. I'm not Karen Winter. My name is Joe Pitano, and I'm from Santa Clara County. I am a parent. I understand there is mothers who've been abused, but there is fathers who've been abused.
Amen.
This is a child molestation being placed with my 2 children. This man right here. I have here evidence, called a psychologist, and evidence this guy is a 3 strikes you out. I have evidence that this guy has raped other children before my child. I have a judge who says it's all right to put a child molester with my children, written and signed by him. He is a candidate, 3 strikes you out. So I know, only thing to take away from me is I'm protecting my child. Trying to protect my child. I'm too emotional. I had death threats, a DA, who's running for the DA. He says, I prosecute child molesters and lying to the public and placing my child with the perpetrator. Same judge was presiding him on the municipal court, now he's back on the family court, knew about this, appointed an attorney, and the attorney lying. I have documentation to show evidence that he had misleading the courts, say how great this guy is. My father-in-law is a molester, molested my children, molested my wife. She married to this child molester. Now what Karen says here is true. I know her. But there is evidence here if anybody wants to look. There is my child too. I'm a parent, I'm a father. I never abuse my children, but they abuse my child. And he deals with guns, illegal alien, came back from Mexico, came back with the different names. There is evidence here. Court records, 3 strikes you out, we have evidence here.
Thanks, Joe.
Thank you. And this is a fact. We need accountable.
Good morning, Ms. Winter. I'm Stan Cosgrove, Napa County. We have a situation in the same issues before the state. We have one case I have personal knowledge of, and it's an interesting case because it's so well documented, and the way the strategy went in front of we'll call it a dirty court-appointed evaluator, was that the evaluator was held up on criminal charges were in felonious ways. That was endangerment of a child. Formal motions put before the court, and which became more interesting was also with the attorney felonious motions, felonious behavior, motions presented before the court. Yeah, and asking for the remand of investigation in order to show cause. All the supporting facts and the charges were very serious, were unrefuted. The court denied the litigant, the respondent, to not only to bring an investigation, but also denied the respondent to further depose to find information and discovery, which is a due process right. Now, what we have here is, where do you go when the Stonewall comes to this magnitude? I mean, this is so...
Shine a light on it.
Exactly. And how do you do that? You know, and what we find is that the judges are not a lawful, it's not a lawful beast, it is a political beast. And what I recommend is the very scrutinized documentation, supporting facts. You have to play within the room of the court. You have to also address it and the issues outside the room. But those have to be supported, they have to be documented, and they have to go through the process. But in our case here again, we have situations of, speaking of money, where the use of corporations that are nonprofit are used between attorneys to judges to evaluators, and how the money flows. But here again, how do we get it up in front, except with the news or whatever?
I just think the study exposure will eventually embarrass the officials into doing the right thing.
It has.
Can there be a way that can there be some type of a format where, almost as of a public listing, a public acknowledgement, and possibly public notice or whatever in our newspaper, so it can affect the counties on a more personal level?
You mean to identify the so-called culprits?
Exactly.
Is that what you mean?
Exactly. Some type of format or structuring of this where these people have some accountability. Right now, confidentiality basically removes that issue of accountability, because you can't get the word out.
Well, I think that any public exposure, as long as what the cases have merit, and I mean, assuming what you said is true, I believe that exposure is the only way, either through the newspapers, through billboards, through announcements. Now, I've known of a lot of people, or just lately, somebody from Pennsylvania was trying to do exactly that. She wanted to document the problems, and the paper wouldn't let her put a notice in it.
That's exactly what happens.
That's what happens.
Back there.
Yeah, my name's Dr. Linda Bernard, and I'm not a court-appointed evaluator. So. However, what I do is many people, such as yourselves, hire me to write rebuttals to 730 evaluations and other sorts of things. And what I find is, because I'm not one of those selected few on the court list, and don't want to be, by the way, that many times judges won't let my evaluations in. They refute them. I recently just had a commissioner over in San Mateo County, basically when I was refuting parental alienation syndrome, didn't read my report except for the first page, but then put in the record that Dr. Bernard is throwing out the baby with the bathwater when I was talking about parental alienation syndrome having no merit. So some of us are trying to do some things to fight back. What we're essentially fighting against, though, is that it seems like the court evaluators, the attorneys ad litem for the children, and all the people who are involved seem to all sort of support each other, and it's a closed system, and anyone who asks any questions about it, and believe me, I'm good at asking questions, the system is closed so that they don't want anyone such as myself. I'm essentially an expert in domestic violence, but it's sort of reached out because of the work that I've done with these kind of cases. So essentially they're trying to shut us out, but I think what we've got to get is some sort of legislation so that there's accountability for the people who do these evaluations. When I do a report, I have to support everything I say because I'm not one of the chosen few. And I do, but they don't. So it's like I'm playing on one set of rules and they're playing on another. And until we get that legislation changed, that's what we're going to be doing.
I'd like to interject here on that note regarding legislation for accountability. We do need the public to notify the governor that the public also wants the bills that are going right now that we have support for in the legislature, but we do not necessarily have support yet from the administration for the funding that we need. Deborah Ortiz's bill is the first bill that says that if you do an evaluation in this type of case, you must enter into your report those essential pieces of evidence that every really good qualified evaluator would enter, but we know many evaluators do not enter those in the report.
Okay.
Along with that is the funding that's needed for the trainings on child sexual abuse for all evaluators and all family court services people. I would like to say that last year, after Deborah Ortiz's bill that addressed the problem of taking custody away from people who make a report or seek treatment for their child, Judicial Council came to us and said, we want to work with you, we want to sit down at the table and set standards. We know we have a problem. And they have raised the issue of children in the family courts to a priority level. They are meeting with us on a continuing basis, and there are people at the state level who are extremely concerned about this. It's going to take time to work that through the system so that we have the people who are actually training family court services people, letting them know what's needed to do this kind of evaluation. But a basic problem in these cases is that we don't have now, we never have had, the resources to do a real investigation of child sexual abuse for these kids. We don't have an MDIC interview on a lot of these kids. We don't have forensic exams. We don't have an evaluation by a real expert who knows how to evaluate children according to their developmental level. And we don't have the funding to do it right now. It's not there. And so that's another side of the problem. The other side of the problem is that we have always had high conflict cases in family courts. And there should be ways of dealing with those. It is completely inappropriate to deal with a high conflict case by then changing custody and saying that you're going to punish parents in those cases. The issue of parents having to work their problems out in a way that doesn't injure a child is an issue in family courts, and they need resources to deal with that. Right now they don't have resources to deal with that. It's extremely underfunded, even though we know that some of the resources they do have are being misused. So I'm saying that at the level of the administration, Governor Davis needs to hear from the public, needs to hear that it is extremely important that we actually fund the multidisciplinary interview teams so they're available for every child. And we actually fund family court services so that we can do new trainings that don't exist right now.
I just want to say one thing, is that in many of the cases in this investigation, there were interviews at the by the MICI. There were,
But they're not
Forensic.
required to be in the report, so the report can currently be submitted without those. If Deborah
They were-
Ortiz's law goes, if this goes into place, then if they submit a report in this case and the MDIC interview exists, they'll be mandated to put it in their report. It will have to be included. And if it's not included, they have to give a reason why an interview was not done or include another interview.
okay. Back there, you,
My name is Peter Romanowski, and I'm from Marin County. And, I went through a divorce 16 years ago. I was married to the county supervisor's daughter, chairman of the board, Ernie Kettenhofen, whose best friend was Mr. Bagley at the state assembly here. And I was so terrorized. I felt so terrorized by the legal system in Marin County that I never went to one of my divorce hearings. In 16 years, I was so terrorized. I thought they would evaluate me as some type of mental case because of my born-again Christian, fundamental religious beliefs. They had made allusions to me being off for believing in the Bible and Jesus, that type of intolerance. But 6 years after my divorce, I found that the only channel I had left, because I was so alone, like so many people, so alone. I'm going off on a slight tangent. I meant to address his concern on the grand jury here. The grand jury, the special grand jury, we're conducting a recall right now against the presiding judge who stepped down as presiding judge as a result of Karen Winter's report and resulting outrage.
He didn't step down, he only moved himself out of family law, and it won't take place till next January.
But we still have him on a recall list, and two other judges, depending how many signatures we get, we're gonna, we might only be able to recall one. If we recall 3, fine. But I have found, as Secretary Treasurer,
Stop those judges right now in their tracks and remove them from the bench instantly, and they refuse to do it. And all they're going to do with your legislation is ignore it. And I can tell you, I've sat in, I can't count how many courtrooms, and I have watched them ignore the legislation, make rude comments about the legislators and stuff like that. They are gods unto themselves, and they don't give a goddamn what you, the legislator, or the governor says. Now that is the honest to God truth. Now if you want to effect some change, impeach every one of those son of a bitches because they need it. Right here in this county, right here. You see this? This is 79 exhibits of sexual and physical abuse against a child. It was put before Judge McBride. Stand up, Carol. This lady won her case. Do you understand? She won the case. Right? You know what Judge McBride did? Dismissed it and will not give her a judgment. And told her, and I sat there in the courtroom, that if she tried to get a judgment, he was going to have her arrested and prosecuted, even though she won the case. All this right here. Sexual and physical abuse of a child. This guy is violating federal law by taking the child out of the country with forged passport information. He knows it, the Judicial Council knows it, and they're covering this kind of stuff up. All the legislation in the world isn't going to work. You got to impeach these bastards, and you got to start right away.
I'd like to respond by saying that I certainly acknowledge, and it's very clear, that there are corrupt judges and that there's corruption here that's not going to be taken care of by legislation. But I also want to acknowledge that in the whole area of child sexual abuse, it's only in very recent years that we acknowledge child sexual abuse at all. And family courts were never set up to evaluate. There is no process right now. There is no structure. There are no standards. And when you have a situation where you have no standards to investigate and you have no procedure, then you have left the door wide open for corruption and for anyone to come in with any unscientific theory and
Then why did the Judicial Council take
perpetrate on the courts. So I think we need to approach it both ways. I certainly applaud everything that you're doing. It's necessary to work on all fronts. But one of the fronts that we need to work on are also the statutes in this state. They don't address child sexual abuse. We have a long, long history of denying that sexual assaults take place at all, whether on children or on adults. We've made some progress in the area of rape and domestic violence, and we are now beginning to make progress in the area of child sexual abuse. It's one of the hardest nuts to crack because it's in all socioeconomic stratuses of our society. It's everywhere. You can't just point to the poor, you can't just point to certain elements of society and say that goes on there. Child sexual abuse goes on everywhere. It's generation to generation. It's as likely to be taking place with physicians and judges and attorneys as it is anywhere else. So it's the hardest nut to crack.
But the Judicial Council took away our right to a jury trial in family court issues. Juries are the trier of fact, okay? They did that because they knew this was a hot issue and they don't want it dealt with. How can anybody think that you don't have the right to a jury trial to protect a child? The Judicial Council did that. They can't do that under the Constitution, but they did it. And what has the legislature or the governor done about it? Nothing. Okay? The problem is in the courts. The corruption is there. They're a third branch of government. There is no oversight, or if there is, you guys or the legislators aren't doing their job. Impeachments should start going right now for violation of constitutional law. The most basic one, for God's sake, is the First Amendment right to speak in a court without being shut up, and the right to a jury trial. For God's sake, you can't get a right to a jury trial. Think about that. Think about that. No right to a jury trial in a family law action, but they can stigmatize any parent who raises the issue. A jury trial, a trier of fact, a jury would never stand for that. Never. Because they would call in and they would want to hear from all witnesses, not just a select few that are on the list. So the thing you've got to do is restore immediately, at least, the right to a jury trial in family law. And then the other thing, too, is put video cameras in the courtrooms like they did in Solano County. Solano County has very little of these problems because everything is right there on video. The reason the video works is because when you have corrupt judges, they change the transcripts after the hearings, or they tell the transcriber what's to put in the report. And I've seen that with my own two eyes. I've seen it in her case.
She was fired because
I'm telling you right now, the legislation isn't going to work. The Judicial Council controls the laws. They're going to play you guys like a fiddle. They're going to play the governor like a fiddle. You've got to investigate them individually, start putting them under arrest, and start getting them help. I'm telling you, if you want to fix these problems, if you want to fix them, get rid of them, give us the right to a jury trial and video cameras, and this is going to go away.
Jury trials immediately.
It's a multi-faceted problem. It's like an octopus.
The jury trial is
So
not
at this
multifaceted. It's a constitutional guarantee. We've got to get it back.
And we're working as hard as we know how on different facets of it. I certainly appreciate your feelings on it and would hope that you begin that process also. You know, each person has to do it themselves. And I would suggest that every person in this room write a letter today to the governor with your
Yes.
I would also just bring to your attention that while you're experiencing it in the family court, it's in the juvenile courts also. And what we really see is that the resources of the courts have not been given to problems that involve children, whether it's in the juvenile court or in dependency situations, or whether they're in family court. The money that it costs to do a jury trial is not going to be expended on a child in our current court system. We have a problem of prioritizing for children in the court system.
Well, that I
It's a
agree
big
with 100%.
problem.
Absolutely.
What you're hearing in very emphatic, and understandably very emotional terms, is that there is no enforcement designed into the laws. He's right. This gentleman is correct. I know from my own experience and my own research that this is true. So you've got to go that extra step. When you design, you draft a piece of legislation, and let's say it gets passed, you've got to incorporate the ramifications for non-enforcement. Otherwise, what he says is absolutely true. It too often is abused, ignored, and it becomes worthless. And you lose our confidence. You're going to lose our support as to working with you. Personally,
we don't have 3 and 5 years. Our kids are left with the abusers, and we want them home today. We don't have 3 to 5
Carol
years.
hasn't seen her daughter for 4 years, no
We
phone
don't have
contact,
to.
nothing, and the sexual pedophile has the child.
you must write
She's been
into-
completely excluded.
You must be
Her.
explicit
That's-
when you write
we
these
don't have
pieces
this
of
time.
legislation. Non-compliance will result in the following. You must lay
Removal from
that
office.
out. You must give timetables. You must delineate fines or whatever. But you must be specific.
Absolutely.
Do not leave this vague, and do not leave it absent, because it will be ignored too many times.
Yes.
And then it's going to take how many more years for us to come back
Yeah.
and say, look, you've passed a piece of legislation, it's good intent.
We got laws that
Not
don't
being
follow.
enforced, it's being ignored. So we're going to throw away another 3 years trying to get this one, a rider added onto it. You must do it in the beginning.
Yeah, the judges have no accountability, they can do whatever they please, and the evaluators too. They can confabulate an evaluation with no evidence, they can project, they can fantasize, it's admitted into evidence as if it were true, and you have no recourse. You can't report them to the Board of Behavioral Science Examiners and Medical Quality Assurance because they say, well, they're court appointed, so we have no jurisdiction over them. And the judges, you can
And
show
also
them the laws and they
The other problem
Don't
is that
care.
these are essentially child endangerment cases.
They
And they're
all are.
misfocused into custody disputes. And they're not about custody or high conflict.
Right.
They're about a child in danger.
Right.
Protecting a child.
And they're protecting the pedophile or the
Yes.
abuser.
Absolutely.
What's happening.
Absolutely.
And we have good laws, we had good laws, they don't follow the
They
law.
don't follow
More
them.
laws aren't gonna
That's
help.
right. That's right. They make up their own law, just like they made up that PAS, whatever it is, parental alienation syndrome, which was made by Richard Gardner, who is an apparent pedophile himself, and they're following.
Richard Gardner he's made some pro-pedophile statements which are in my report. So on the
Right.
one hand, you have the prong where they're saying where the proponents of PAS are saying these people complaining about abuse are hysterical, they're coaching the children, they don't like their other parents, so they're coaching them. But on the other hand, these same proponents, and I've documented this thoroughly, make some extremely pro-pedophile statements such as Richard Gardner, such as sexualizing a child is good because once a kid has sex, then they're going to procreate better for our
What an
species.
idiot.
Yes,
That's in the report. So you have something extremely underhanded going on underneath
Perverted.
the allegations that this is about coaching and false charges.
I want to
Let's hear
say,
from the people who have not had a
Right.
chance to speak,
Okay, this
okay?
sir,
Yeah.
Thank you. I just wanted to say that to back up what the other guy was talking about, the Judicial Council, I have personal experience. I sent a challenge to the judges here at juvenile court because I've been acting in social court for years. And they sent back my challenge denied, saying that the referees are supposed to answer my challenge under oath against being biased, and that they had only denied the allegation that they were disqualified, and that's the only thing that they had denied. Meanwhile, everything else in my challenge evidently must be upheld since they didn't deny any of it. So the Judicial Council didn't help me in that situation, but I think we're only touching the tip of the iceberg here. My children were taken after false allegations and false reports were filed, and it's actually CPS doing a lot of the child abuse here in this state, and they need to be accountable. And that's why I have a federal civil rights lawsuit against them, against therapists who labeled me in denial without ever looking at the facts, to see that over 90% of the charges they made against me were false, and that what I had done did not rise to the level of child abuse, but was inappropriate discipline. And I also, besides that, I'm suing certain social workers and the Board of Supervisors for failing to supervise these people in their actions since I've had a claim against them for over 8 months. My case is amendable to class action and to whistleblower suit because they are not following the laws, as this gentleman pointed out. They're not following the laws that are meant to protect children. When they automatically take children for 6 months as one of the standard procedures, should tell people, hey, wait a minute, everybody doesn't need to be taken for 6 months so they can figure out whether they want to keep them longer or not. I just got my older daughter back after 14 months of fighting, and I still haven't seen my younger daughter in that amount of time. So evidently my home's safe for my older daughter, but it's still not safe for my younger daughter who I haven't seen in 14 months. Something wrong with the logic here. I proved that social worker reports and police reports had lies on them, and school officials had been lied to, but they ignored all that. They excluded evidence from 1 year ago and wouldn't let me have it. It took me 3 subpoenas to the sheriff's department to get most of the evidence I needed for them. But the other evidence was deemed irrelevant since it's a year old. The same court ruled that a case from 14 years ago was relevant. Now that's a double standard that I'm complaining about, but you know what? That's deaf ears out there. Now this judge that's out there, Kenneth G. Stonewall Peterson is the name I gave him. He just came into the system a couple years ago, so it was already bad when he got there. But they're right. These judges, the judges' judicial immunity is overshadowing these social workers. And my oldest daughter's lawyer just told me the other day that she comes out of the courtroom crying because she can see the injustice that's done in that courtroom every day, and she can't do anything about it. And she's one of the smartest lawyers I've met out there, and she can't do anything about it because they only let what goes in the social worker report go in there. I have a psychologist and a therapist that they ignored his recommendation.
Honest with you, I have been accused of having my child's by proxy. I was accused of this because my daughter has she had legitimate surgery. She was dealt with by a pediatric gastroenterologist. At some point, because she was in the hospital with pancreatitis, as I was told, the nurse there contacted CPS. CPS in California did an investigation. I went to Stanford, I came back from Stanford, I contacted CPS and said, do you have a problem with me? On several occasions, if I called once, I called 14 times. Do I need to do anything? No, you're fine. I go to the hospital. I happen to be in Reno because I live in South Lake Tahoe, so where do you go? I ended up in Nevada. My brother said, sign temporary custody until you get well. I was really ill. I do this because my husband works 40 hours a week at Forest Service. We figured that would be best to have her on the weekends. He turns around, he made it into general, whatever, you know what I mean, guardianship. I did not know this. I signed a paper that said temporary. It was only supposed to be until I was well. He turned it into general. I was not subpoenaed properly. I find myself making my own petition. I go to court, right? On the way to court, we total our car. The next thing I know is my brother is saying, I don't know what, in court. On Monday, my daughter's being taken into foster care. Okay? Now I'm finding myself as a very modest income, and I don't have money for an attorney, so they give me a court-appointed attorney in Nevada, right? Then they say, you have to have a psychoval. Well, I've had a couple of psychovals done. One was a 3.5 hour with the dots and the whole 9 yards by Dr. Young in San Francisco, Daly City. She says, you're fine. I do have a disability. I have a back problem. I have to have a psychiatrist for my pain. Okay? And I've been doing that. He writes a letter to the court and he says, look, I've seen the
I would like to invite each and every one of you who has not already seen it to read my case in Karen Winter's report. Because on the surface, my case looks like it's not as egregious as some of the things that I've heard. However, what happened in my case was that my child's court-appointed attorney created illegal orders to divert my child's support directly to her and a psychologist that she chose to do an assessment. Now, what complicates the issue is Judge Duffy, who, incidentally, I need to say this publicly, and I think this is very important. Both Judge Duffy and Commissioner Shapiro are known to be alcoholics and drug addicts. So regardless of the illegal activity, regardless of ignoring procedures, regardless of all other kinds of things, they are basically incompetent. They are alcoholics. They are active. They fall asleep. Judge Duffy does not pay attention. He reverses his decisions. He says one thing. 2 days later, he says something else.
Sounds like Senator Burke.
Okay, but I do want to say that underlying it, the problem is the attorneys. What I discovered in my case, and it wasn't until I started providing documentation and talking to Karen Winter, and then I started meeting some of the other people in Marin County. My child's attorney, and her name is Mary Halbert, she is partners with 2 of the other attorneys that were named in the report. She tends to refer people, like myself. I had a valid restraining order against my ex-husband for threats to me that were pretty serious. Mary Halbert, when Judge Duffy would not, well, my ex-husband was trying to get the restraining order invalidated. Mary Halbert took it upon herself to rewrite the restraining order and bring it to Commissioner Shapiro when Judge Duffy wouldn't even sign it. She changed the restraining order. Then she wrote herself into getting my child support. Then she created who she wanted to send me to for therapy. Well, it turns out the person she sent me to for therapy is associated with a group that contains all of the special masters, all of the psychologists that were also named in Karen Winter's report. So even though mine wasn't, she was kind of a silent person associated with it. Well, guess what? Guess who's the chairperson of the board of the overseeing psychological group? Verna Adams, who's an attorney who was named in the report, who's now a judge. Well, guess who's also the chairman of the board of the spin-off group from that? Clay Green, another attorney who's named in that. So the underlying problem is you get these attorneys, they manipulate the laws, they prevent legitimate psychologists from releasing certain critical information, they distort what the psychologists say, they come up with